afternoon, Your Honor. Melissa McNeil on behalf of Nikolas Cruz.
Diane Cuddy on behalf of Mr. Cruz.
Chef Marcus for the state of Florida.
And Sherry Tate for the state of Florida.
Your Honor, Alex Arias on behalf of the Borges family that's the victim.
Okay. All right, Mr. Cruz, you've been charged by indictment in count 1 of the indictment with murder in the first degree of Luke Hoyer, a first-degree felony punishable by up to death, as the state has filed its notice of intent to seek the death penalty in this case. Count 2.
Your Honor, we're weighing formal reading of the indictment at this time. We have been provided with a copy of the indictment from the state of Florida. We have reviewed that indictment with Mr. Cruz. He is aware of the charges that he is facing.
The only issue is how do you stand mute and waive formal reading?
In terms of entering a plea, we stand mute, Your Honor.
Any objection to the waiving formal reading?
No objection.
Okay.
Your Honor, can I be heard on the matter though before you arraign?
I'm sorry.
Can I be heard I had filed 2 motions before, and I thought they had to be heard before the arraignment could take
Mr.
place.
Arias, I am aware of your motions. I got them this morning. Whether or not you have standing, I don't know, but certainly the parties have had the opportunity to respond, and I'm not going to throw this on at the last minute to respond to your motion to disqualify. I guess the whole circuit is what you're wanting to do. Is that correct?
It is, Your Honor. It's outlined in the motion, so if you're going to put it on for another day, I'll explain that to the Borges family, if that's what you're saying.
What I'm saying is I need an opportunity to review it.
I understand.
And then I will make my decision as to whether or not I want the parties to respond or I'm going to set a hearing. Okay? The only other matter I think that needs to be addressed today is okay, so if you're waiving formal reading and you're standing mute, pursuant to Rule 3.170C, a plea of not guilty shall be entered on the defendant's behalf on all 34 counts of the indictment. I'm going to enter a plea of not guilty on his behalf and set the case for a calendar call on April 27th, which is a Friday. Does that work for everyone?
That's fine, Your Honor. We would just like to advise the court and the state of Florida that at any time Mr. Cruz is willing to enter a plea of guilty on all 34 counts, consecutive life sentences, in exchange for the waiver of the death penalty.
See, is that the trial date, Your Honor, that you just set?
The calendar call date, yes.
And will be there, and would the court set a trial date as well?
Sure, it'll be the following Monday.
All right, thank you.
Okay, the only other thing I wanted to ask is whether or not the Office of the Public Defender is still asking me to inquire as to the indigency of the defendant?
Well, Judge, I have a couple things I'd like to put on the record about that so I can let the court know what efforts the Public Defender's Office has made.
Okay.
If I may approach the court, I can provide you with some documentation. I have an unredacted copy for the State Attorney's Office. Your Honor, this is partially redacted. I would just request that the court verify that any numbers are in fact. I went through it, but if I missed anything, I would ask the court to review that.
But as to numbers, as in
account numbers, social security numbers, I believe that I got everything. The copy that I provided the state is unredacted. I'm not concerned with them releasing that information without redacting it.
Okay,
but
what is it exactly that I'm looking at?
These are the documents that the Public Defender's Office has obtained over the course of the last month in an effort to make a determination as to whether or not Mr. Cruz was in fact indigent.
Okay.
We, as the court is aware, we were appointed on February 15th of this year, and immediately thereafter there was a lot of media attention as to alleged assets that Mr. Cruz or the estate of Linda Cruz had that due to her death he would be a beneficiary of those monies. So as a result of that, we reached out. We know that there was a medical malpractice lawsuit that was filed on behalf of Linda Cruz and the children as a result of Roger Cruz's death. We made efforts to obtain a copy of that court file, and we're advised today that the clerk's office has purged the medical malpractice lawsuit. I provided a copy of the certificate from the clerk's office as well, provided it to the state. So we were not able to inquire into the contents of that file because it's been destroyed. We do know that at the time he was arrested, the estate of Linda Cruz was represented by a probate attorney. So we reached out to the probate attorney and we provided the court with some documentations about email conversations that we had with those attorneys after we received a waiver from our client requesting if there were any wills, any information that they may have in their possession as to what constituted the estate of Linda Cruz.
Okay.
We sent that email to counsel on February 20th. We did not receive any information from them initially, but we also provided them with a copy of our motion that we had filed but not set, requesting the court to determine indigency. They had requested, as you can see when you have an opportunity to review the emails that I provided you in the state, that they asked us to delay setting that motion because they were making efforts to try and go through the information that they had to assist in making a determination as to whether or not he was indigent. During that time, we made contact with a gentleman by the name of William Bromley, who was the estate attorney for Roger Cruz back in, I believe, 2005 and 2006, in an effort to try and make a determination of what assets may be available as a result of that. We were advised that Mr. Bromley, he advised us to contact the firm of Haber and Blank, which we did, and as the court can see there, that firm provided us with an affidavit, and the only thing that they could advise us is that the real property, the Parkland property, was short-sailed on January 12th of 2017. That property was listed in the probate file, which I've also given the court, the probate file of Roger Cruz, as the real property valued not in excess of $1 million. So that house was short-sailed. Okay, so that's some of the information that we have found out. We also followed up with probate counsel, requesting once again, Mr. Weeks did, copies of wills, copies of life insurance policies, balances of any funds that they may have relating to Linda Cruz, or any open accounts that they had information for Mr. Nikolas Cruz. And yesterday, March 13th, yes, yesterday, we were provided with an email with attachments that I provided the state and Your Honor that has an open checking account for Linda Cruz and Nikolas Cruz. Those documents indicate that the balance is $12,309.70. We only have one bank statement, and something that may be of interest to the court on page 2 of that bank statement, it's actually page 3 of 6, Your Honor, halfway down, is that there is a deposit, and I don't know if this is a quarterly deposit, a monthly deposit, we don't know that because we only have one statement, from Metropolitan Annuities in the amount of $3,333.33.
Where do you see that on page?
If you look at the top, it's page 3 of 6 of the Wells Fargo bank statement, Judge. That's obviously a substantial deposit, but I don't have any details. September 27th, Your Honor.
Thank you.
We don't have any details about that, but we know that there may be a possible annuity that was going to his mother, and therefore he would be eligible to receive that, as well as his brother Zachary. We also know that, and I provided the court, that there are several savings bonds in Nikolas Cruz's names. They range from $50 to $100. There is a Microsoft, looks like it may be a share, I don't know. And it doesn't have an amount, well, it says 24 shares in Microsoft dating back to 2003. I don't know the present value of those shares. We also know from a pleading that the probate attorney filed on March 12th of 2018 in her rule to show cause on paragraph 12 of that motion. She has indicated, which you do not have, Your Honor, but it is available on Odyssey,
Okay.
that She, meaning the probate attorney at that time, who is no longer the probate attorney, indicated that she was aware of furniture from the decedent's last known resident, an engagement ring worth approximately $5,000, some furniture, some crystal figurines, a grand piano, and a Louis Vuitton wallet, as well as some credit cards and some debit cards, and a bank statement, and a 2015 Kia. So, although we did file the motion on February 15th, the day we were appointed, and we held off on filing it at the request of the probate attorney who had access to all of this documentation.
Okay.
But in conducting our due diligence, we were able to gather some information. What this information means in terms of his net worth, I don't know that. But I wanted to bring to the court's attention and to the state of Florida, this is the information that we have about assets that may be potentially available to Mr. Cruz. Oh, and there is one more thing. 2 days ago, I received a call from Allstate, and I'll supplement that because I forgot to copy it for you guys, is the life insurance policy holder for Linda Cruz. She had a $50,000 life insurance policy that was to be split between Nikolas Cruz and Zachary Cruz. That check is ready for disbursement. It is still in the possession of Allstate because there's issues about how we need to get that to Mr. Cruz.
Okay.
So that is the extent that the Public Defender's Office is aware of any potential assets that Mr. Cruz may have available to him.
So we're talking about $25,000 life insurance because he would have to split it.
That I know 100% about,
Okay.
yes.
We've got a bank account with upwards of
$12,000.
Wouldn't that in and of itself, those two things, mean him not indigent?
Well, Judge, Chapter 27, which deals with, if I may have a moment, I printed. So Chapter 27 deals with the determination of indigency in the state of Florida.
Okay.
And in reviewing that chapter, and during the evolution of that chapter, there was contemplation of the offense. So that if somebody is charged with a third-degree felony,
Okay.
let's say a possession of a cocaine, they may be indigent, but somebody who is charged with multiple counts of first-degree murder, where the state of Florida is seeking the death penalty, they may not be indigent. So we are researching the legislative intent behind Chapter 27 because the chapter itself doesn't specifically make that distinction. However, it's my understanding that there was some discussion in writing of Chapter 27 in contemplation of cases of first-degree murder in a death penalty case, because
Okay.
somebody who is indigent for a third-degree felony may not be indigent for a first-degree murder charge. And in this case, we have 17 counts.
So what are you asking me to do today?
I'm letting the court know what the Public Defender's Office has in their possession. And the only representation that I can personally make is that I know that there is a $25,000 check that will be coming to Mr. Cruz once we figure out how that can be dispersed to him. And then I'm just giving the court the information that we obtained. I'm not in a position to interpret that. I'm not a probate lawyer. I'm assuming that the probate attorney that has been retained for the estate of Linda Cruz will be doing that. So I don't know if the court is inclined to perhaps set this for 30 days out to give any interested parties an opportunity to come forward if they do in fact have information about any monies that would be owed or eligible for Mr. Cruz, and then the court can make a determination once we do a more comprehensive review of Chapter 27 as to whether or not contemplation of the offense is a factor that the court should consider in making a determination of whether or not somebody's indigent. And we also, as of today's date, we have notices of 3 lawsuits that have been filed where Mr. Cruz is listed as a party. And I do know that in a determination of indigency status that there is a contemplation that there's a due process service creates a substantial hardship for the applicant or the applicant's family. So that's just another thing. We don't have to deal with it today, but for the court to consider in the future when you make that determination. I'm assuming that there's going to be other lawsuits that will be filed where Mr. Nikolas Cruz is named as a party, but the only ones that I know of today are 3.
I mean, ordinarily what I would do is I would just ask the defendant to fill out an updated indigency application, and have them indicate what assets they know of that they currently have. I mean, because it could change at any time, right?
That's correct. It's
So
a fluid
it's
situation.
what he has access to currently.
Well, currently he has access to no funds. He can't go into a bank and withdraw that $12,000. It would have to be, I guess, a private attorney. If he was able to obtain a private attorney, would have to gain access to his funds. So I don't know how that aspect of it works because I'm a public defender, so I don't deal with the financials.
But he does have a legal right currently to the $12,000+ in the bank, as well as a $25,000 check, so it would be $37,000.
He does, in fact, have a legal right to those funds that we're aware of. However, for the bank account, Linda Cruz is also listed there, so I'm not sure, not being a probate attorney, whether or not those funds have to go through probate, and that means that it would be dispersed between himself and his brother. So there's just a lot that we don't know because this involves the estate of Linda Cruz. But I just wanted to bring to the court's attention what we did know.
For now, why don't we go ahead and have him fill out an updated application indicating to his knowledge what he currently has. Steve, do you want to hear?
Judge, we would just ask if you're going to appoint the public defender's office today, that it's subject to review upon the disbursement of the funds, that we have a hearing and review it in 30 days or sooner if they find
you all
out.
have already been appointed, have you not?
Yes, Your Honor.
Okay.
Yeah, on the
So,
15th of
I've
February.
only had one other case where this issue arose, where an individual had a trust fund, and as it turned out, did not have access to any of the money. So, this is sort of the first time that I've been dealing with something of this complex nature when it comes to somebody's finances and whether or not they're indigent.
So if the court is inclined to have us refill out the application for the public defender's office, I would ask that you just reset this and maybe even till tomorrow so that we can go out and meet with Mr. Cruz.
Sure.
I don't believe that we have the opportunity to speak freely with him as his counsel in present circumstances. So whenever
That's
the
fine, and then
court...
why don't you just file the updated application? And then what were you all suggesting, that I reset it in 30 days? And
Well, I'm not educated about all of his assets. There is a probate attorney that has been retained for the estate of Linda Cruz. 2 days ago, I believe. I'm sure that he's in the process of reviewing all of the documentation. He's going to be the person that's going to have the information about what money will be going potentially to Mr. Cruz. Right now, it's just speculation. So I think if we give that individual, and his name is Jose Lorenzo,
Yes.
an opportunity to do what it is that he needs to do. It's my understanding that he is trying to obtain some of the probate documentation from the original probate attorney, and Judge Green signed an order requiring that attorney to turn everything over to Mr. Lorenzo. That would just give the court a more education to make the appropriate decision than the information that we have today.
Okay, anything else?
Judge, I have some orders to hand the court before we're done with the proceeding today. The state and the defense entered into a stipulation. We filed a 10-day notice to get certain medical records and mental health records, school records. So the 10 days has elapsed. That would allow us to seek a court order, but we've also entered into by stipulation with defense counsel. So I've got the orders for Broward Health, for Henderson Behavioral Health, for South County Medical Health Center, for Jerome Golden Center, for Broward County Clerk of the Court, for District of Palm Beach County Schools, and Broward County Public Schools. So I have an order that we've all stipulated to for Your Honor to
You all
sign.
presented this to me previously.
Yes, Your Honor.
You're just saying that the 10-day notice period has elapsed, because this is familiar. You all are agreeing to these
Yes, Judge, of course.
requests? Great, now go ahead and sign those. Anything else that needs to be addressed?
No, are you resetting this? Did you decide we're going to reset it for tomorrow, or are we going to do a review in 30
As
days?
far as I'm concerned, and if you all want to provide me some insight, as far as I'm concerned, his financial situation is what he currently has access to. So if he can currently access $37,000, whether it be through, I don't know how you would do that either, a private lawyer or whatever that is, if the clerk says that he's not indigent, based on that updated information, then unless the public defender's office is asking for a hearing on it, I think I would just discharge you from the case.
Well, Judge, what I would like, if the court is inclined, is to set it for 30 days. We will submit that documentation to the clerk's office and speak with Mr. Lorenzo and see if he can expedite what he is doing so that we can provide the court with the information. I do not believe that there is anyone, private attorney in the state of Florida, that would take a 17-count first-degree murder case for, I think Your Honor said 32, what was the total?
I was just adding the 25,000 that you said, and then
So
the
approximately
total of the bank
37,000.
account was about 12,000. So I was just giving an approximate number.
Right. So that's my point is, given a little bit more time, I would have an opportunity to research the contemplation of the offense under Chapter 27, which is how we make the determination of indigency.
I mean, if you all are willing to stay on, and your office is willing to conduct discovery and do whatever else it is that you would do if you were representing someone else, with this being in limbo, I don't have a problem with that.
I just would like the court to have all of the information that they need in order for you to make a determination, an accurate determination. And that's why we filed the motion for a determination of indigency, and I just believe that there are more parties that are involved in that determination, or parties that can bring forth information to the court than the one that is standing before Your Honor, meaning the defense.
We would like it set for 30 days.
That's fine.
While the amount of money available to him may not pay for his entire representation, if he becomes indigent, then there is a mechanism for that attorney to get costs.
Sure. Okay, so you want me to set it out for 30 days for an indigency status?
Yes.
Okay. How about April 11th, which is a Wednesday at 1:30? Does that work?
It's not spring break, is it?
I think spring break is
Yeah.
in March.
March, sure. Okay, that's fine, Judge.
Does that work for you all?
We'll make it work.
Okay, thank you. We're in recess and I'll sign these right now.
Your Honor, shall we just wait for you to make a determination on those?
Yes. Thank you.
Thank you.
Can I have a blank application, Judge, that I can...
Sure.
I can get one from another courtroom. That's okay.
I don't know. Maybe over. No, it didn't. No? Okay. I know we have them next door.
I can get one.
If the clerk can certify them?
We can, if you'll need us to collect them and set it.
I can,
We're guests here.
that's fine.
We don't know where
That's
everybody
fine. I can send some. Are you going to be over there, Your Honor, this afternoon?
is. We can go right over there.
Okay.
I have a hearing right after this.
Okay.
Okay, thank you. 77.